Good morning, everybody, and welcome to this 30-minute breakfast briefing with me, Kaz Carrington of KLC. Just a few things before we start on this rather dreary Tuesday morning. Liv Harris from GoHo is providing technical support this morning, so thank you for that, Liv. So anything of a technical nature, any problems you have, just put something in the chat and Liv will be on it. We can't do any answers in the chat box or emails answers today. But if you do want to know anything more about understanding fixed term contracts, because that's going to be the subject of this morning's offering, then you should consider coming along to the Law on Tour. So the Law on Tour is an event that I write every 6 months. So it's brand new product every 6 months. And then we take it out on the road and it's a day-long employment law session. Now, I know that employment law training can give you the yawn factor sometimes and can be a bit dry, but that's not our style at all. And it's a really nice day out. You get to hear everything that's new in employment law, all the case law, all that's coming along, all the codes of practice, all those sorts of things. You get to also look at some perennial issues that HR face every single day practically. So we pick some things that we sort of focus on for that particular day. You get to meet like-minded and people who are of a different mind, HR folk. We have a nice lunch. And we have a few laughs to boot as well. So it's a really, really good day. And then you come away with some very comprehensive documentation. So we're going to start off in Cardiff on the 18th of April. Then we move to London, then on to Leeds. And then the following week, we're in Manchester on the 25th. And then we're back in London on the 27th. And then, of course, we have our webinar on the 5th of May. For anybody who really can't make any of those dates. And if you can't make the 5th of May, the webinar, once you're registered, can always be viewed at your leisure, at your convenience, because you can view the recording of that. Just to say that anybody who wants to book on the Law on Tour today, if you do, after 10 o'clock, the first 5 people, we're going to be offering 10% off the next Law on Tour. So if you had a mind to do that, that would be a good thing to get under your belts. Okay, so questions we've talked about, technical supports we've talked about, and they are the contact numbers for us should you wish to book on. So as you can see, if you're a registered charity, you get 20% off anytime, all the time, and that's our website detail, and that's our email address, and that is our telephone number down there, and I'll flick that up at the end just in case any of you who want to book on, so you can do so. Okay, so the subject of the day, fixed term contracts, and this is what we're going to be covering. So what is a fixed term contract? What are we talking about today, Cass? Why a fixed term? Why would you want to put somebody on a fixed term? Notice issues, looking at the regulations, not in depth, but a nod to them, just to recognise that there is a piece of law that governs the treatment of people on fixed term contracts. Looking a little at fixed termers and redundancy, because that's often something that can be tricky. The end of the term, what happens then? And as most of you will know, the non-renewal of a fixed term contract is a dismissal at law. How do we make that dismissal fair, and how can we make it unfair if we don't know what we're doing? So that's our agenda for the next 30 minutes. So first of all, what is a fixed term contract? Well, it is very much what it says on the side of the tin. It is a contract where we have a start date and a finish date. It's for a fixed term, but that's not the whole story. It could be that we will say that you'll start on a certain date and the contract will end on the occurrence of something or the event of something, a specific happening, if you like, or on the completion of a particular task. So I'm bringing you in to write this new manual, and when that's done, actually the contract will be at an end. Often we cover maternity leave with fixed term contracts and other types of family leave. Now, if you're covering for a maternity leave with a fixed term contract and you've got somebody in, you don't exactly know how long the incumbent of the job is going to be away. They might decide to return very quickly after the baby is born, might decide that being at home looking after the baby isn't for them after all, and they want to return by giving you the requisite 8 weeks of their early return. And then we will have the person returning to work, and the person who is filling that role, that will be the end of their contract. So the way that we do that often, isn't it, is we say that this is the beginning of the contract, it's for a maternity cover, and the contract will end when the job holder returns from maternity leave. So we've set up a fixed term because it's going to end on the occurrence of that event. But not only have we set up a fixed term, if we set that out in writing before the fixed termer commences the maternity cover, then we've set up what we call an automatic, some other substantial reason. And that means that even if the fixed termer at some later stage says, well, actually, when you let me go when the job holder returned, that was in some way discriminatory, or it's some way in breach of the regulations, or has some claim about the fairness of that dismissal, we can say, well, actually, it was for some substantial reason, and it's one of those situations where the tribunal have to take that as read. It will be a SOSA dismissal, in other words, for a potentially fair reason. Okay, so that's something to bear in mind, obviously. Well, why do we employ people on fixed-term contracts? Why indeed? Because as we know, as if you don't, you'll sort of soon do, that people on fixed-term contracts really have the same rights as somebody on an open-ended, or shall we call it sort of a permanent contract. So why do we fill some positions on a fixed term basis? Well, it could be that you have a finite piece of work. There is something that you know that needs doing, but actually when it's done, there is no longer a requirement for an employee to do that work. It obviously things like covering other leaves as well, or it could be covering somebody on sabbatical. It manages somebody's expectations. So although they will be entitled to more or less the same rights as somebody on a open-ended permanent contract, we are giving them the heads up that don't expect this contract to be indefinite. Don't expect this contract to last forever, because the flag is that it's for a fixed term. Okay, so that's why we do it. Now, what we don't want to do, and where I think people tend to get in difficulties, is where, for example, they'll just bring people on a fixed term contract, well, because we're getting over the fact that we don't have to give people employment rights. Well, clearly that isn't the case. As I explained, people have just as many rights who are on fixed term contracts. I'm not suggesting any of you would do that, but you can understand some unscrupulous employers might do that. Okay, so let's talk about notice and fixed term contracts. Essentially, you don't have to give notice in a fixed term contract because the notice has been given at the outset of the contract. So if I say to you, your contract's going to start on the 1st of January and end on the 30th of June, I'm effectively giving you notice that that's when the contract will end. But of course, often we do talk to people during the course of the fixed term contract. We'll say, well, actually, we don't envisage renewing it, or we do envisage renewing it because maybe this person is good and we want to make sure we secure them. They don't go off and find a job with somebody else. But sometimes we see contracts of a fixed term that don't have early termination clauses in them, which means that effectively, if I'm saying the contract's for 6 months, unless you do something which is a fundamental breach of that contract, let's just say, a gross misconduct matter, then if I want to end the contract, I would have to pay that contract out in full. And so we have an early termination clause, and we can do that for no cause. So I'm just giving myself the right to terminate that contract at an earlier stage than we have envisaged at the outset of the contract. So it's really, really important. Other thing to bear in mind, again, sometimes we don't see so often, is inserting a probation clause in the contract. Now, let's just say you have a fixed term for 9 months, and you have maybe somebody who comes along and they're not so good. And you're thinking, oh, crikey, what shall we do? Well, we can terminate early for no cause, without cause, but actually, are we treating that person who's on that fixed term less favourably than somebody who would be on a open-ended permanent contract? So that's a bit of a concern. Now, in a probationary period, we always allow ourselves, don't we, the ability to be able to do lots of things. For example, the person might be on a shorter notice period than they might be on later on. We give ourselves the right to circumvent procedures, don't we? We say the full performance procedure won't apply to you, or the full misconduct procedure won't apply to you. We may terminate during this period. So we're giving ourselves a lot of leeway. So if it is for a period of 3 months, it's probably not worth doing. But if it's a period for 6 months or 9 months, then and you don't know the individual, then it's well worth having a probationary clause within that contract to give yourself a little bit more leeway, as much leeway as you possibly can. The more flexibility we build into a contract, the easier it is for us as employers to be able to, if you like, manage that contract, and the less likely it is that we'll be breaching the contract in any way, because we've given ourselves permission to do certain things during the term of the contract. Now, under the Employment Rights Act, in section 86(1), it addresses minimum statutory notice. And what ERA says is that after 1 month's continuous employment, employees are entitled to statutory notice. And as you will know, in terms of an employee's rights, that goes from 1 week up to a maximum of 12 weeks. So it's 1 week for each year of completed continuous service with a maximum of 12 weeks. Now, there is, you can see, I'm sure already, a way that if you were an unscrupulous employer, that you could get around that. You could think, right, well, I'll bring somebody in on a 3-month contract, and then I'll just keep renewing them. I'll have a bit of break, I'll keep renewing them. And that way I can avoid giving notice altogether. Well, there is an exception at section 86(4) of ERA. It says that somebody who's employed on a fixed term of 1 month or less, but extended and has continuous employment of at least 3 months or more, is treated as a contract for an indefinite period. So if you like, it moderates, section 86(4) moderates the way section 86(1) works to make sure that people on fixed term are protected. Okay, so it kind of plugs that little loophole which otherwise might be there. Okay, let's move on to the regulations themselves. So the Fixed Term Employees Prevention of Less Favourable Treatment Regulations 2002 rolls off the tongue very neatly, not. So the regulations are about 21 years old now, and they obviously protect employees who are on fixed term from less favourable treatment. Now, they don't apply to apprentices. That's the first thing to note here. How does somebody on a fixed term make a claim? How do they show that they might have been treated less favourably? Well, they have to have a comparator. As in most things where we're talking about less favourable treatment, I've got to find somebody who I'm comparing myself to. So we're looking for somebody who is working for the same employer at the same establishment and doing broadly similar work. So this sounds quite familiar for you with regard to maybe equal pay matters. If they're not in the same establishment, or if we haven't got a comparator, if you like, in the same establishment, if my employer's got another establishment, then I might be able to compare myself to that person in that other establishment. And I'm looking for somebody who is on comparable work, who's not on a fixed term contract. So obviously doesn't share that characteristic, if you like, of being on a fixed term contract. So this less favourable treatment that the regulations sets out, what sort of thing does the fixed termer get protected from? Well, the terms of the contract themselves must not be less favourable than somebody offered terms on an open-ended contract. They mustn't be subjected to any detriment. So that could be, for example, if you say you need to be with us 8 months before you can apply for a job internally, you can't have a different qualifying period for a fixed termer. Because if they're on a 9-month contract, then they would have the right to be able to do that at that 8-month period. So the periods of service qualification for benefits must be the same. Training opportunities must be the same. The opportunity to apply for permanent positions, we must make it possible for the fixed termer to be aware of those opportunities. And most employers these days, in the olden days, we would put it on a notice board and we'd go along and see the job vacancies. Very much now it will be on an intranet and the individual will be advised of that. So it's much easier effectively to be able to evidence that we have given the fixed termer the opportunity to apply for the job should they want to. The pro rata principle applies, obviously. So where we can, we will provide the same benefit, or if you like, a prorated version of that, unless we can objectively justify not doing so. So where we can, we offer comparable benefits. If we can't offer that benefit because of the nature of the fixed term, it doesn't allow us to, for whatever reason, then we might offer, a different benefit which might be of the same value. And if we can't offer the benefit altogether, then we have to be able to objectively justify that. Now, the comparison is not like equal pay when it comes to looking at, well, what's my package? I can look item for item and compare myself with somebody who I'm saying I need equal pay with. When it comes to a fixed term contract, what we're looking at is the total value of their remuneration package. So as long as we can say, well, we couldn't give you that benefit, but we gave you that instead, that's what we're looking for in that respect. Okay, so limiting the term of a fixed term contract. So often we see, don't we, contracts for 6 months, contracts for a year, contract for 18 months. And if some organisations who say you can't issue a fixed term contract for more than 18 months. So does that limit or impede the individual's ability to gain that continuous service and therefore have more rights? For example, to have the right to claim unfair dismissal, the right to claim a redundancy payment, statutory redundancy pay. Well, actually, that was actioned very early on in Webley versus the DWP. And Ms. Webley was on a series of fixed-term contracts, and she was let go at 51 weeks. The end of her contract happened, and basically you couldn't be extended beyond 51 weeks if you were employed on a fixed term contract, because they had open competition rules. And so nobody on a fixed term could go beyond 51 weeks. Well, obviously that's going to deny her a year's service, which at the time this case was run was all she would require to bring a claim of unfair dismissal. So it ran, the Court of Appeal said, look, if we were to say that you can't actually have a fixed term contract for a period of 51 weeks, that would negate the whole principle behind having contracts for a fixed term. So that is not less favourable treatment. So effectively, if you want to restrict somebody from gaining rights, and you say, well, 103 weeks or 100 weeks or 18 months, whatever you want to say, that is not going to be a problem for you. Somebody is not going to be successfully running a claim because the Court of Appeal have looked at that back in 2005. Okay, what else do the regulations do? Well, they do moderate the number of successive fixed-term contracts that we can give an individual. And what the regulations say is that if the individual has 4 years or more on successive fixed-term contracts, then they become permanent by operation of law, effectively. Okay, so it's just one of those things. We have to tell them that they are, but they don't have to fight for it. They would become permanent. Unless it can be objectively justified to actually continue giving them more fixed-term contracts without them becoming permanent. And the case you can see there, Duncan and others versus Secretary of State for Children, Schools and Families. It was a Supreme Court decision, this, and it was where we had people on fixed-term contracts. They could have fixed-term contracts, successive fixed-term contracts for up to 9 years. These were teachers in European schools, and this was effectively governed by a rule which said that they couldn't be employed for more than that 9 years. When these contracts got to the 9-year period, 2 people actioned them saying, indeed, this wasn't objectively justifiable, and they lost. The Supreme Court said the fact there had been this regulation that meant that teachers employed by these European schools were governed by that rule, that it was objectively justifiable. So that's a case which looks at objectively justifying the use of successive fixed-term contracts above the 4 years where somebody was not considered to be a permanent member of staff. Okay, what about redundancy then, and how do we deal with that? Well, again, we've got no less favourable treatment for fixed-termers. When would it be justifiable to select somebody for redundancy on a fixed-term contract over somebody who was an open-ended employee? Well, if you're bringing somebody in and I'm saying to you, your contract's for 4 months and that's going to be it, and then I have to make some reductions in my staff, I'm not going to pull everybody together and say, okay, well, I'm going to put you all together and see, who comes out the best, because I can objectively justify saying that contract was coming to an end. I'm going to say end of that contract, and I'm going to then effectively choose you to be the person who's redundant. However, if I've had lots of people on successive fixed-term contracts and they've gone on and on and on, and they might have quite a lot of service now, they might have 2 years, even more, then I would be at pains, I think, to argue, oh, well, you always knew you were going to be for a fixed term, because clearly I've extended them on several occasions. And there the argument for maybe pooling people, making the pool for selection larger, is much stronger. It might be much harder to justify selecting those people on fixed term contracts. That would very much more look like less favourable treatment. The rules of collective consultation, obviously, when we're in a redundancy situation and we propose to dismiss 20 or more people in an establishment in any 90-day period, then we're into collective consultation. Now, what do the rules say about fixed termers? They now say that if the fixed term will come to an end, effectively the redundancy date won't break the fixed term, then we do not have to count those fixed termers in our numbers, our threshold numbers, for determining whether collective consultation is triggered. So I've got 16 permanent people and 4 fixed termers. If actually I'm going to break their contracts by the redundancy, I'm into collective consultation. But if not, if actually their contracts will just end, then they are not going to meet my or make up my numbers for collective consultation. Okay, I've already mentioned that the non-renewal of the fixed-term contract is a dismissal. That's what ERA says. Section 95 is quite clear that employing somebody on a limited-term contract where the contract terminates by virtue of the limiting event without being renewed on the same contract is a dismissal. So obviously where we have a dismissal, we need a potentially fair reason for that dismissal. because the contract's not being renewed. So what is that potentially fair reason going to be? And we should consider this. Regardless of whether they haven't got 2 years service, you should always know why you are not renewing that fixed term contract. Because of course somebody could say, it was automatically unfair, I don't need 2 years service because actually you didn't renew me because, I don't know, because I wanted to be a health and safety rep, or because I wanted to assert some other statutory right. So where we are not renewing because of the person's conduct or capability, let's say it could be their poor performance in this fixed term or their behaviour, we want some kind of evidence. It doesn't necessarily have to be a sort of full procedure, but we want to have some evidence to be able to say, that's why we didn't renew that person. By the way, we told them so at the time that we weren't happy with their behaviour or performance. It could be redundancy. It could be that we no longer have a requirement for employees to undertake work of that particular kind. Our requirement has ceased or diminished. That is the definition of redundancy. So it could be that. It could be that their right to work in the UK has expired. That would be a statutory bar. That could be the reason. Or it could be some other substantial reason, one of those reasons. So it could be, for example, as it was in this case, that the individual wasn't successful in a job application. Now, Mistress Miller had been working as a locum doctor in the hospital for quite a few years, and then they decided that they would make the position that she was working as locum in permanent. So they advertised, and they had 2 candidates. She was one, and there was another candidate for the role. The role was actually as the acute oncology breast cancer doctor, which she was obviously eminently qualified for, but so was the other candidate. And after going through an interview, Mistress Miller was told that she hadn't been successful. Now, bear in mind, she'd been on a series of fixed-term contracts for a number of years. She was told she was not successful. She wasn't given the right to appeal. And she wasn't actually helped in terms of them looking for alternative employment for her. Now, what was the potentially fair reason for dismissal? The non-renewal of her contract, because it was going fixed term, we now need a permanent, so your contract's not going to be renewed. It wasn't a redundancy because clearly they still had a requirement for work of a particular kind ongoing. It wasn't conduct, it wasn't capability, it wasn't statutory bar. It was for some substantial reason, which would have been fine if they had pursued a fair and a reasonable process. But by not giving her the right to appeal, by not looking to see if they could redeploy her, although it was a potentially fair reason, it wasn't a fair process. So where we have somebody in such a position, not necessarily a doctor, but who has got those successive fixed-term contracts, they've got the service, we have to be extra especially careful that even if we've got a fair reason to dismiss them potentially, we have to follow a fair process as well. And as I mentioned, does it matter that they haven't got the continuous service? Well, sometimes it doesn't. So always be aware that we've got to really be clear about why we are not renewing. Somebody's got 2 years service, they're going to be able to bring a claim of ordinary unfair dismissal. If they've got less than 2 years service, there may be a reason that they can still bring a claim against us. So we've got to be able to point to something and say, that was the reason we're not renewing. Their performance wasn't really up to it, the standard we expect in our organisation, and what's more, we told them so vis-a-vis our email to them dated the 13th of March, etc., etc. Okay, so that is really, really important. Okay, we've nearly come to the end of our 30 minutes, just scratching the surface as we do in these 30-minute sessions. But just to remind you, if you want to know more about fixed term contracts, this is one of the things that we're going to be looking at on the Law on Tour. And remember, if you want to get booked on and you do it today after this session, the first 5 people will get 10% off their next Law on Tour. So please give that a go. They're the numbers to call, the emails to contact, the website to look at. Just thank you very much for joining me again on this breakfast briefing. I hope to see you again in 6 weeks, 2 months' time for the next one. In the meantime, have a great day, and let's hope this weather cheers up soon. So for now, bye and take care, everybody.